afternoon. We are grateful to have a case that does not have significant portions of the record under seal. Our next case, Woodcock et al. Versus Cumberland County Hospital System, Inc. et al. And we will hear from the appellant.
May it please the court, I'm Doug Harris of the Greensboro Bar. I represent the plaintiffs, Doctors Woodcock, Waden, Waba, and Dimitri. Although this case comes to you in some fashion as an attorney's fees case, I would suggest respectfully it's more of a 41A dismissal without prejudice case. And I say that because, as you're aware, and I'm aware, North Carolina is more of a forgiving state on 41A dismissals than a lot of states are. And it's worked well for us. It provides good access to justice, and I think it allows attorneys time to correct errors, time to correct problems that they have. Some of those problems come up more commonly in cases with contracts, where the contracts are hidden, where things are done behind the scenes, which is alleged here. And it comes up commonly where there is a breach of fiduciary duty, which is alleged here. And the point is, sometimes the attorney, when they're asking their clients, can't really learn all the details that they might like to put in a complaint, because the clients don't know themselves, and you don't really know until you start doing discovery. And it's worked well for North Carolina to allow dismissal without prejudice under these sorts of circumstances without penalty. And Justice Sandra Day O'Connor had said, why should we ban the practice that works so well for us in favor of practice that works so poorly for others? And so it makes a lot of sense. The case of Briss and Sandarella, which is in my brief, notes that you can have a dismissal without prejudice for because you fear a rule violation. You might be dismissed because you have pleading shortcomings, evidentiary failures. Anything's all right, really, as long as you're not dismissing in bad faith. And some of the examples of bad faith I can think of that help illustrate what we all know to be true. For instance, in Greensboro, Judge Patrice Hennett, who was one of our judges in Greensboro, she said in open court, "I'm going to dismiss the case, direct the defendant to draw an order," and the plaintiff went right downstairs and filed a dismissal without prejudice. And that was, you can see why that'd be found to be bad faith. Another case, Estrada versus Burnham, it was filed solely for the purpose of extending the statute of limitations, and not in the way we usually do, where we file it, then we learn we have trouble and that sort of thing. It was the attorney admitted he never even tried to serve the case or anything. It was just a blanket thing. They found that to be an abuse of discretion, and we don't have anything of that nature here in a way of an abuse of discretion.
I think the issue here has to do with claims that were brought in individual capacities that seem to be properly brought as derivative claims. At what point should the plaintiff have known that the claims that were being brought should have been brought in as derivative claims?
Your Honor, this is something that came upon us over a period of time to realize what's going on, and even the court stated in open court in the record that this was kind of an open question. It was more settled with LLCs and corporations than it was with limited partnerships, as this was. Even the judge himself stated it was unsettled. So it wasn't at all clear to me that we were necessarily going to lose that point. What was clear to me is that after we'd done considerable discovery, it's quite clear to me that I wanted to withdraw. I could either amend it, which I thought was a bad idea because it needed so much change. I thought the proper thing to do would be to withdraw it without prejudice and refile it, which I've done before in certain cases. And that was particularly true here because we learned a whole lot of things we didn't know. So I thought that was a proper use of the Rule 41 dismissal, and conversely, did not show we were acting in bad faith. There ought to be attorney's fees under whether they're individual pleadings or whether they weren't. That was our feeling on it, Your Honor.
Can I just ask you to be a little more specific about what things you learned that you didn't know before, and in
Yes.
particular, how they related to the lack of standing?
Yes, I'd be happy to. Before I filed, I was aware that there were contracts out there that involved a partnership, which by rights should have been shared with limited partners, but they weren't. I could understand it being kept secret before the deal went down, but once the deal was concluded, there'd be no reason not to share contracts so that everybody know what was affecting, their limited partnership. And one thing we learned was there was something called a contribution agreement and something called a equity purchase agreement, which we had no idea about. Didn't know its terms, didn't know what it said, didn't know anything. And it soon became apparent to me that it looked to me like I might want to be filing a derivative lawsuit in addition to the individual claims, and that was one big example. And then even more as we took depositions and all, I realized there were a lot broader issues going on. And when I refiled the complaint, it was a considerably longer complaint. Did include derivative actions. It hasn't been acted on in any final way, but there was a partial summary judgment motion made, or a partial motion dismissed made, and a few things were taken out, but others survived. And so the bottom line is, right now it's headed on to a trial. So the changes we made were important, and we would not have reasonably known about those changes had we not done discovery, and we couldn't do discovery until obviously we filed suit with whatever form of the suit. So, in answer to your question, we learned quite a bit through that we were, as an attorney, the best I had from my clients was rumors. They were saying, well, we heard this from Joe, and we heard that, and, I really can't write a complaint based on rumors. My clients were profoundly ignorant as what had gone down, and the reason they were profoundly ignorant was because the general partner had refused to even share with them the basic contracts, even after they were completed, after done. And so this was very important.
Wouldn't we have to find that there was an abuse of discretion by the trial court in order to determine that there was some error in the award of attorney fees?
Yes. Yes, Your Honor. We've argued a number of errors in abuse of discretion. The first one was when we came up with a 12C motion to argue it. At the time, we had just started negotiations with Judge Gale, Jim Gale from Greensboro, and we were hoping that's going to be the end of it. And in light of that, I stood up and asked the court, and we're making pretty good progress here. Judge Gale thinks so. I wonder if we could hold discovery and hold off doing anything, any expense by anybody, until we reach some kind of conclusion on this. And the judge said, no, I want you to keep on doing discovery just like you were, and keep on negotiating if you like. And there was no suggestion from the court that he really thought I ought to withdraw the case, or he really thought to throw it out. I mean, instead he was telling me I needed to go forward and needed to do something, and so I pretty much was bound to do that. So I thought that was abuse of discretion, because if it's supposed to be clear to me that I should dismiss my case by what was said, which frankly wasn't clear to me, it certainly was clear to the court if the court felt that way, and the court should have said, I'm getting ready to dismiss this, don't do any more discovery, or whatever.
Rule 41
Yes.
doesn't provide any standalone authority to impose attorney's fees. It's a statute that references the availability of other sources of attorney's fees. So in your view, what is the statutory authority in this case that the trial court relied on to impose the attorney's fees?
621.
So that deals with non-justiciable issues.
It does.
And I'm a little concerned that that's unfortunate wording in this particular case, because the word justiciable has two meanings.
Yes.
One is the very technical concept, we often think of as from Article 3 in the federal courts, the case or controversy concept. So you have subject matter jurisdiction, then you have these justiciability issues, standing, ripeness, mootness.
Yes.
The flaw, I think we all acknowledge, and the case was one that could be described as standing. You needed to bring the derivative action. These were the wrong named plaintiffs.
Yes.
Is that, in your view, when you say justiciable in 6-21.5, is that what justiciable means?
My point of non-justiciable is to put it in plain layman's terms, is where the case is garbage. It's got no business being there. For example, when you look at other non-justiciable cases, they say things like, it was already past the statute of limitations. When he refiled the case, it was dead already. He had no business being in court. I don't think non-justiciable necessarily means you made a flaw in pleading. You should have included more, should have worded things a little differently. And I think this court in the Brisson case supports that view. They say expressly that part of the reason you're supposed to be able to do a dismissal of those circumstances is to clean it up, to make things that were, as it were, non-justiciable or missing elements, to put them in there, to even factual errors, to put them in there. And it's an important saving grace, and I think that's particularly important on cases involving these sort of problems, like a hidden contract and that sort of thing. So,
and I assume in your view then, if a plaintiff filed a case in which the plaintiff ultimately lacked standing,
yes,
and so the trial court, it wasn't a voluntary dismissal, the trial court dismissed the case for lack of standing,
yes,
you wouldn't automatically get attorney's fees under 6-21.5, that word justiciable there means essentially you filed as frivolous. You were on notice that there was no reasonable, rational basis to pursue this claim and pursued it anyway. At what point,
I'm sorry.
in this case then, that suggests that there must be a point at which a trial court, in order to impose fees here, determines, okay, you knew you shouldn't go forward any further.
Yes.
And can we, in your view, can we look at this order and say that the court was doing that, parsing out these, I'm going to impose attorney's fees for these portions of the case? From some point where you had gone far enough, you should have known now and everything forward? Or was this just, I'm imposing attorney's fees because I've concluded your entire action was non-justiciable?
I think the court in this scenario should be looking for bad conduct, something that's wrong, something that reasonable attorneys, for want of a better word, would know that this should not be done. This is gross error. I think that's what we're looking for here, and I think that's borne out by the rules of dismissal anyway. When you see those people in those cases have made many errors. They've made mistakes in the law. They've made mistakes in the facts. The courts say, this court says, as in the Brisson case, we don't care as long as you clean it up by dismissal and come back and make it right. We don't care, and as long as it's not in bad faith. If it's in bad faith, you're going to be punished. Bad things are going to happen to you, and they do happen to you, and rightly so. So I think, in short, when this was dismissed without prejudice, I think the judge should have let it be and let there be normal damages, as it would normally when you reform a case and refile it. I appreciate the fact that the case needed more work. That's why I wanted to dismiss it and reform it. That was the whole point.
Counselor, as a follow-up.
Yes.
And I'm looking for a clarification.
Yes.
In reading your briefs, I struggled with whether you were actually arguing that because of the incorporation by reference to some documents, that there was a breach of fiduciary duty in your allegations. Have you abandoned the fact that there's not a direct claim here? Or how are you arguing, and how are you using that argument? Was it to say that it was reasonable for you to continue to believe, or do you still continue to believe that you actually pled a direct claim? I've struggled with understanding what your position was. If you could clarify it for me.
I will. Let's just say, for the sake of discussion, that the judge ruled that very day, as judges often do, and said, well, Mr. Harris, I just don't think you got it. I'm going to dismiss you for 12C. I think that we would have a legitimate reason to appeal that down here for that, based on the fact that there were independent claims there. There were personal claims there. You may have seen we cited the contract itself said this was a contract with each other, not just with the company. Each of the people were contracting with each other. And when a contract is violated under those circumstances, you do have an individual claim. Now, I'm not suggesting that I don't think it's a better idea to do derivative too. When I refiled, I did individual and derivative. But I am suggesting that we thought it was a decent claim, we filed it. As I got more into it, I thought, I really got to have derivative in here. You know, this is, from what I've learned, that's obvious. This is a fault against the corporation as well. Against the limited partnership, and answer your question. And,
So you filed I guess, a first amended complaint, then a second amended complaint.
yes.
Have any of the causes of action from the second amended complaint been included, I guess, in this new action and have survived?
Yes, sir, they have.
Which claims, or what is the nature of the claims that have previously been pled that currently survive?
The breach of fiduciary duty is still going forward. And the judge, the court did throw out some of the individual claims, not based on this, because by then we had a derivative claim too, but based on the fact that the general partner had signed not for the limited partners, as you might think, but had signed for the general partner individually. And so the court felt like we didn't have a good signature, in other words, on these contracts we were contesting, in answer your question.
So it looks like that your various causes of action in your second amended complaint all have to do with breach of contract. When and where was this breach of fiduciary duty raised?
I'm sorry, I didn't quite follow it. When,
I'm looking at your second amended complaint.
oh, yes.
And your second amended complaint seems to have various causes of action that all address contract claims.
Yes.
Where is the breach of fiduciary duty claim that you say still has vitality in the current suit? When
That's in a document that's not before you. It's in the new complaint under the Article 7.
So my question was, which of the prior claims?
Oh, I'm sorry, yes.
Which of the prior claims that you made are currently viable in the current suit?
I believe it's that one, the breach of fiduciary duty in number 7.
Okay. I've
And-
just
and
read through the second amended
I
complaint.
may have to stand be corrected if it's not in those complaints, but I believe it was. It certainly came up during depositions and all that sort of thing.
Well, it's not in the second amended complaint.
All right.
And I don't believe we have the first amended complaint in our record. So none of the contract claims that were alleged in the second amended complaint are viable.
No, they're going forward, Your Honor. They are viable. They're in the new complaint too. The breach of contract. Yes, sir. The breach of contract is pled under number one of the newly filed complaint, which is, you know, after we took a dismissal without prejudice and refiled it. And that part of the complaint is all about breach of contract. And I'm actually getting ready to file a summary judgment in favor of, because we think it's a matter of law they breached the contract there. And answer your question. Now, I also wanted to speak to some things.
What proportion of the attorney's fees that are awarded here is for the discovery, the cost of the discovery that was conducted? Roughly, do you have an estimate?
I don't know exactly. I took 2 depositions of perhaps several hours apiece, and for my discovery, I asked for whatever had been given. This involved the purchase of the general partner, and I asked for whatever was supplied as due diligence for the purchase of the general partner, and so we got quite a bit of paperwork on that, some of which wasn't very useful. I mean, many pages.
But and did you argue to the trial court that discovery would be conducted, ultimately would be conducted in the refile case anyway?
I did. I said we haven't wasted time. We're still going forward. We're going to use what we already have. I of course have done more discovery, and I haven't redeposed those people at all that I deposed. We're using them just as they are.
So under 6-21.5, in your view, was conducting that discovery non-justiciable?
I don't think so. I think it was just I thought it was in pursuit of what we said the problem was, a breach of contract. And I thought it was taken in good faith, and certainly the first thing we would have had to know in the new complaint, had we not done discovery, we would have had to have the information that had been supplied during the due diligence, which is exactly what we had to have anyway. So it took us a long way down the road where we didn't have to ask questions again, didn't have to take depositions again, to answer your question. And
Counselor, if I might follow up to Chief Justice
Yes.
Beauty's question, and I'll phrase it perhaps in a little different way that might help me understand. Can you point me in either of your two amendments or your original complaint where you actually alleged the contract issue? I know it's been discussed. You say that it was brought up in discovery, and it's now, it sounds like the focus of this second suit, this refiled suit. But can you point to me in the allegations, the actual language, where you, if we look at this from a standing position, that you actually say that you actually pled it?
that there was a breach of contract?
Yes.
Yes.
But can you
That was
point
the-
me
that-
to the language? I know you say you did, but I'd like to know how you
I think it's
how you did
difficult to read the complaint without seeing that it's alleging breach of contract. I mean, that's what it's all about.
Well, the way I read the allegations is that you had incorporated by reference the document and then have since made an argument about it. And I did not see the language that you actually pled that way, but I'm very open to hearing how that might be, because I may have missed something.
Yes, that's true. But part of the breach of contract had to do with the fact that there were two sections, 14.5 and 13.4, which had to, which were plain in the contract that said that certain people could not purchase the general partner, and we believed that applied to to Cumberland Hospital. So we said they had violated 14.5 in particular, because it said that if the person or entity purchasing the general partner was in direct competition with them, which we contended hospital, the surgery center was, that was a breach of contract. That we pled that specifically.
Well, if I might follow up, one way to read your allegations, well, let me phrase it differently. Is it your position that by incorporating that contract by reference, that would cover this issue of the breach of contract?
Not all by itself, no.
So what else would be required?
You simply have to plead the elements of breach of contract, that there was a contract, which we pled, the 1995 agreement, that it was breached and there were damages. We pled all three of those things.
Well, thank you.
And argued that to the court as well.
I'll
And
read
the court
them.
didn't have a problem with that. The court had a problem with the fact they were individual, individual damages. That's what the court seemed to be concerned about.
Right,
My impression.
but for it to get to be an individual claim, it would have to be a properly read contract claim, I believe, and
Yes.
pled. And so that's
And we
what's-
pled contract.
And that's,
I-
well, then, excuse me, why would the court then have a problem with your having standing in a direct suit if that was properly pled, if that were properly pled?
Well, I don't know, because the court kind of talked both ways. The court at one point said some things that made me think we were going to survive. The court said some other things, principally about the derivative, made me think we weren't going to survive. And I frankly don't know how the court was going to rule for sure.
Thank you.
Yeah. And I also raised the issues, which I don't want to neglect to mention. There were some odd circumstances in this case where evidence was allowed in that we were not allowed to see and not allowed to rebut. Now, we've all seen things allowed in sometimes that are viewed in camera, and we appreciate what those are and all, but 99.9% of the time, one party stands up and says, because of its personal nature or whatever, we want this viewed in camera. And you have debate about that or not. What was odd about this was that the court, without anybody asking, without anybody saying there was anything ought to be viewed, just said flat out, I'm going to view this in camera, and didn't allow me to see it at all or argue about it. And this is something covered by North Carolina law, where the claim or defense turns upon a factual adjudication, constitutional rights of the litigant to an adequate fair hearing requires that he be apprised of all the evidence received by the court and given an opportunity to test, explain, and rebut it. Henri Gupton. That's 1953, your decision. And then another oddity occurred. We had actually finished in the sense that they had made their arguments. I'd made my reply. I was all done. And the court had already said there weren't going to be oral arguments. And the court then sent a memo and said, I'd like to see the material that wasn't included for the attorney's fees request. I'd like to see the part you didn't request attorney's fees for. And I thought that was right odd because, you know, what do you want to see something that's not being discussed at all? And it suggested, and the court never said they didn't consider it, it suggested the court was considering it in some sense. And if so, we thought that fit very neatly under the Bandy case that this court decided a couple of years ago, which said that it's an abuse of discretion to consider evidence that is not part of what you're supposed to consider, not part of what you're charged with deciding on. And the court was surely not charged with deciding evidence about what wasn't being asked for attorney's fees. And so that just a true oddity. And
Counsel, you did not reserve rebuttal time. Would you like to?
Yes, thank you. I'll hold the rest for rebuttal.
Thank you. Hear from the appellee.
May it please the court. Chief Justice, Associate Justices, my name is Susan Hackney, and I am with K&L Gates, LLP. Here today with me are my co-counsel, Marsha Rushley and Daniel McClurg. We appear on behalf of Appalachia, Cumberland County Hospital System, and also Cape Fear Valley Ambulatory Surgery Center, LLC. The issue that is before you today is whether the trial court awarded defendants' attorney's fees as part of cost, where the plaintiffs persisted in litigating their non-justiciable claims despite receiving notice from defendants on multiple occasions that plaintiffs lacked standing to bring their individual claims. Defendants only sought fees to defend the second amended complaint. We did not seek any fees for defending against the original complaint or the first amended complaint.
And, sorry to interrupt you so early. but
Certainly.
If I can just, am I correct in terms of the litigation timeline here, that there was no ruling from the trial court? So I'm trying to understand what happened before the time period at which you say fees are starting, the filing of the second amended complaint, the time at which this statute 6-21 should kick in. And it appears that you had filed a motion to stay, and that was denied. So at the motion to stay stage, the trial court could have said, and I believe that you, in that motion, indicated your intention to raise the standing issue. The trial court could have looked at the pleadings and said, there's no justiciable issue here. I'm staying these proceedings. Let's have a hearing on your motion to dismiss and get this out of court before anyone has to spend any more time litigating, correct? But that didn't happen. In fact, the stay was denied.
Well, the stay was denied. We had indicated that we were going to file a motion to dismiss based on a lack of justiciable claims. Right. We briefed the motion to dismiss. That did go to briefing, and then the plaintiffs asked if they could amend their complaint. And so at that time, the trial court accepted their amended complaint as filed.
And wasn't that a second opportunity for the trial court to say, this amendment would be futile? There's no justiciable issue here. There's no reason to amend this complaint. I've read your motion to dismiss in briefs. I agree with you. And let's get this out of the way because there's no issue.
The trial court could have, but it was also at that time incumbent upon the plaintiffs to look at our pleadings, and we went into great detail about why their claims were non-justiciable, that they lacked standing to bring those individual claims because they had not alleged one of the two exceptions to the general rule that an individual cannot bring claims for the benefit of the partnership itself, on its own. And so I believe that while the trial court could have, also at that time, the plaintiffs could have taken a dismissal.
Right, well, I mean, there's always a motion to dismiss, and the plaintiff said here, he said, I didn't know for sure how the court would rule. I mean, isn't that correct? He didn't know for sure how the court was going to rule until the court actually ruled.
But I think it's different when you look back at your complaint and see that the law says clearly, in order to bring an individual claim, you have to file one of two exceptions. Either that you have a special duty that's alleged, or that there is a separate and distinct injury.
Right.
And let me just finish my sentence here.
course.
So when plaintiffs, based on their responsibility to look to see if their claim was justiciable, there was nothing, they clearly had not pleaded that. And they could have at that time dismissed their claim and then re-alleged. But what they did do instead was they amended their complaint and still didn't even fix it. They amended their complaint and went forward with only individual claims.
And you had the ability to seek a hearing on your motion to dismiss, correct? You could have asked the trial court to rule on the proposition that you're saying they should have acknowledged and just.
We did not get to hearing on the motion to dismiss.
But you had the ability, couldn't you have filed a request for a hearing or notice, set it on the calendar?
We were going to until the plaintiffs asked to amend their complaint, and the trial court, they attached it to their brief, and the trial court took that amendment and considered it filed. If you look at their order, it says, we've accepted as filed the second amended complaint. And so I believe it didn't go to hearing because they accepted that. And we didn't have that opportunity to do that. And at that point, we did not know whether we went forward with judgment on the pleadings because we wanted to make certain that this didn't get amended and amended and amended.
And you did have a hearing on that motion?
And the judgment for the
Yes.
pleadings, we did have a hearing on that motion.
And there still, though, wasn't an order from the court saying, yes, defendants are absolutely right. On the pleadings, there's no justiciable issue here.
The court made it pretty clear in there, if you read the transcript, which is in the record, the court made it pretty clear that they did not see a justiciable issue. They discussed the fact that there was nothing in the pleadings alleging a right to vote. There was nothing in the pleadings that stated that there was a breach of the individual section that provided for a right to vote. And as you know, this is a notice pleading state, and in order to allege a breach of contract, we have to have notice of what provisions of the contract were breached.
And those statements made by the trial court from the bench were in the hearing on the motion for judgment on the pleadings in September of 2020?
They were in the motion for judgment on the pleadings. I forget the date. You're probably right.
Okay, thank you.
A couple of things that I want to point out on your earlier questions. You had asked about the direct claims in the newly filed case. All of those claims have been dismissed. Only what stands are individual claims now. You also, Mr. Harris spoke of
Can you repeat that? Only what remains?
only derivative claims remain in the case that is still live. I also want to point out that,
Do
I
you,
think,
do you dispute your friend's contention that some of the discovery that was conducted after the filing of the Second Amendment complaint may be relevant to the claims that still remain?
you read my mind, I was just going there. I think it was in response to your question, Justice Behringer. You asked what they learned and how they related to standing. The 1995 LP agreement, which is what plaintiffs allege provided them with the voting rights that they say were breached, which gave them standing, was the contract between the limited partners. Dr. Woodcock, the plaintiff, well, all three of them, I mean, all four of them, Woodcock, all four plaintiffs, let me just say that way, are limited partners. And so they had that contract. Moreover, the contribution agreement, although I would contend that that contribution agreement had nothing to do with individual standing, those documents were provided to plaintiffs prior to the second amended complaint being filed. And, you know, as I said, we didn't seek fees until the second amended complaint. We gave them benefit of the doubt that maybe they didn't understand. But after our motion to dismiss, we had set it out very clearly as to what was required in order to bring individual claims, and there was no change to bring derivative claims in their second amended complaint. Another thing that Mr. Harris said, and I believe
Excuse me, counsel. In follow-up to Justice Deet's question, can you specifically answer the question, was any of the, in your view, is any of the discovery that was discovered, that was found, or not found, but discovered in the first suit now being used? If you could just give that in simple answers as opposed to giving examples. Do you think that some of that is being used?
I don't believe so, Your Honor.
Thank you.
Counsel, just to follow up on that, suppose that some of the discovery in the current litigation, or suppose some of the discovery in the prior litigation is relevant to the current case. How would that affect our analysis?
Some of the discovery in the current case,
Some of the discovery that was conducted in the first lawsuit, suppose that some of that is pertinent to the current litigation. How would that affect our analysis?
I understand what you're saying, Your Honor. I believe I understand it. I don't think that that affects the analysis here, because even if it's used, the discovery that's used later, I think is what you're getting at, it did not relieve their burden for their continuing duty to look as to whether that was a justiciable claim. And they could have conducted that discovery after they dismissed and refiled and gotten the same thing. Some of the discovery that plaintiffs claim in their briefs before you are, one of the things is the PPP loans. The PPP program had not even been put into effect at the time of the second amended complaint. And so it was never alleged, nor could it have been alleged. And we actually had filed a BCR 10.9 discovery dispute claiming that that wasn't a proper subject for discovery because there was no allegation in the second amended complaint that went to the PPP loan. There also was no claim, just to clarify this, for the breach of fiduciary duty in the second amended complaint, as you said, Justice Newby.
And to be clear, the only derivative claims are surviving at this point in the new litigation.
That's correct.
So just, very straightforward, in a straightforward manner, why is this just not a typical failure to state a claim, like subject matter jurisdiction? What makes this different? Why should attorney fees be awarded here when not in the run-of-the-mill 12B1, 12B6?
Because ordinarily at a 12B1 or a 12B6, you haven't already been told that your claims are non-justiciable. You haven't been told. And we had gone, like I said, our brief went through all of the case law. And as attorneys, we are required to analyze that and determine how that affects our claims. And so that's why, though, that we didn't request fees until the second amended complaint. We gave them the benefit of the doubt that prior to that, maybe they didn't understand derivative claims. And then they persisted in filing a second amended complaint that did not allege derivative claims, and they persisted in litigating in the face of that information. And I think that that is the difference here. They also, as we have talked about in our briefs, plaintiffs produced 153,000 documents in their response to our discovery request. And if you'll look at the affidavit of Jen Bortmas, which is in the record, I can give you the page number if I can look through my notes in a minute, but they claimed that our discovery was so egregious because it went back prior to 2008 to 1995. But only 310 of those 153,000 documents, only about 2% were prior to 2008. Also, if you'll look in our motion, now I'm forgetting exactly where it is, but plaintiffs produced, and we have a chart in one of our pleadings that shows the spam emails that were in there. And we put the numbers of them, and there are things like political ads and other things like that. I added those numbers up, which aren't added in our brief, but I added the numbers that we have in those charts. 23,000 of those documents were spam emails. And they produced those without obviously reviewing their documents, or else they would have held them back. And again, Jen Bortmas's affidavit is pretty telling on that in terms of what she shows happened with the discovery. She is with our EDAT, our electronic data analysis. She's an attorney, and she provided an analysis of that data for us. And so that is a difference too, Justice Newby, is that what we were required to deal with during the course of the litigation was unnecessary.
So we're here with an abuse of discretion standard. And so I'm looking at paragraph 24 of the trial court's order, which I think is kind of where he summarizes, he goes through his reasoning for finding that the plaintiffs lack standing. And this is the paragraph, and you can point me somewhere else if there's a better place, but where if we're assessing abuse of discretion, we have to see, was there a reason, was this a reasoned decision of the trial court? Mm-hmm. And so I'm taking paragraph 24 as where he articulates his reason. And what I'm struggling with is how what he says here wouldn't be true in every case where a trial court dismisses for lack of standing or dismisses generally. Because the mere fact that a motion to dismiss is filed means the plaintiffs are on notice that the defendants think that there's no standing.
But in most cases, that's the issue before you. In other words, there was one motion to dismiss and then a motion for attorney's fees. So in other words, if after our motion to dismiss and the First Amendment complaint, plaintiffs had dismissed their complaint, I don't believe that we would have or could have applied for attorney's fees. We would have applied for costs, but probably not attorney's fees, because they would have realized, they would have taken the situation and not perpetuated litigation in the face of that information. It's not, I mean, you have a complaint, a first amended complaint. You get information that you're required to look at, and then you move forward and file without even correcting or attempting to correct, and file derivative claims, and then you continue through way after the hearing, and I think it's fairly telling, after the hearing, when they filed their notice, their motion for, the motion for voluntary dismissal, they state in that pleading that they're gonna refile their claim to bring additional claims and to bring derivative claims. And I think one thing to look at, obviously, you're correct, Justice Earls, that this is an abuse of discretion standard. I think before that, getting to the justiciable issue, that is a de novo review as to whether there was a justiciable issue. And then there is an abuse of discretion standard. And at that point, it's left to the discretion of the trial judge, who, in his order, I believe, let me find the finding of fact real quickly for you here. In the fee order, the second order, in finding of fact number 15, the trial judge states, in this case, the court is intimately familiar with the course of litigation and has intimate familiarity with the issues, the litigation strategies employed, the discovery and motion practice undertaken before the trial. It has an ample basis on which to opine regarding the match between the task at hand and the skill and experience of the attorneys addressing those tasks. But it also shows that he was very familiar with what had gone on in those, I think it's about 10 months, it's almost a year, from when the second amended complaint was filed and when the notice of voluntary dismissal, not the notice of voluntary dismissal, the motion for voluntary dismissal was filed. We did not seek fees after that as well.
A follow-up, excuse me, Counselor. One of the questions I posed to your friend on the other side was the business or the situation of the issue of the breach of contract and pleading of that, assuming, it's not assuming, but apparently the business court judge determined that that was not properly pled. In that second amendment, is it your position that they could have pled a direct claim and had their cause of action survive, the standing survive, or is it your position that there are only derivative claims possible in this particular conflict?
Looking at this issue, they could have let me put it this way, the individual claims were not dismissed on the same issue. In the case, it's still before the business court. I believe that if they had pled the proper, exceptions and the violations of the contract, et cetera, that would have provided them standing regarding that issue, yes.
Thank you for the clarification.
I want to address the in-camera review briefly. Plaintiffs claim that they did not have the opportunity to object to that, and we would disagree with that. I do believe that it came down in the order for the motion for fees. And then we filed the application for fees, and at that point, plaintiffs had the opportunity to file a response, but didn't object in that response at all to the fact that they didn't have that information. Even so, basically, there is no objection that has been properly made or timely made in order to raise that issue. Furthermore, there is plenty of information within the record in order for them to have had notice and the opportunity to respond. In the Bandy case, that was a notice, and Justice Earls, you're very familiar with that case, but the motion, sanctions as opposed to cost, number one. But here, they knew that they had already been told that their fees were going to be awarded against them. So they had notice of that. Secondly, they had the opportunity, based on our application for fees. We had in there lots of information, and they did not object to the amount of total hours at all. They didn't object to the hourly rates. They haven't objected to the skill of the attorneys. And so they had the opportunity and did take that opportunity. If you look through their brief, they have lots of complaints in there about what they think should not be correct. But I don't think that they did have the opportunity to respond. And in the WFH, make sure I get that wait one moment, make sure I've got the case right. It's three initials starting with a W and then it's Linwood case that's cited in our brief. In that case, the Court of Appeals awarded fees based on a 4-page affidavit from an attorney and found that the fees were, affirmed the trial court there, and didn't have any invoices at all. And I don't think that that's unusual for the plaintiffs not to, many cases in the business court that we cited to don't have, the plaintiffs don't have the invoices to review, that they do hold those in camera. Finally, I want to talk about, very quickly, the findings of fact in these orders. The only finding of fact that plaintiffs have objected to is finding of fact number 1. They have not objected to any other findings of fact. And finding of fact number 1 is the one that says that this case relates to the ownership and operation of Fayetteville Ambulatory Surgery Center Partnership, which owns and operates an ambulatory surgery center in Fayetteville, North Carolina. I think there are a couple of things there that are important to note. If you'll look at the rest of that sentence, it goes on to say, more specifically, plaintiff's claims arose out of alleged breaches of the Second Amended and Restated Partnership Agreement of FASC. And then I think it's important to take note that if you look at all of the findings of fact that they didn't object to in the court's order, for instance, the one that I just quoted about the fact that the court had ample information on which to opine regarding the match between the task at hand and the skill and experience of the attorneys addressing those tasks. They also did not object to any of the other findings, but just notably that the court had reviewed the invoices and associated spreadsheets and generally finds that they reflect appropriate amounts of professional time devoted to the various tasks undertaken by defendant's counsel in this matter, and consequently finds them to be reasonable amounts of fees for such work. They also have available category-specific hours by attorney for 4 different categories of task. One was document review, there were 2 depositions, and then the 12C motion. And they haven't objected to any of those findings on that information. One of the things I think is important to keep in mind here is that Rule 41 actually states that attorney's fees shall be awarded if another statute provides for that. And so I believe that that is where we are here today, that the court awarded those fees pursuant to Rule 41, also pursuant to North Carolina General Statute 6-21.5, and then 7A-305, which allows for attorney's fees as part of cost. And we would respectfully request that you affirm the trial court's decision in both of those orders. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
I have several things I'd like to refute and answer at least one question. The first thing is this statement, no opportunity to object. The normal course of events is that someone makes a motion for things to be put in private to the judge, and then there's an objection or not, and then the judge rules on it. What happened here was, without anybody mentioning it, without anybody bringing it up, nothing said, not a word said, the judge issued an order that they would view these attorney's fees in camera. And they wouldn't be shared with me, and I couldn't see them, I couldn't argue about them. As I understand the rule to be, if a judge makes an order, the next place to take it up to is the court above, you. It's not to object to him or raise something then. When the judge did something other than order, a little later is when he ordered that, or not he ordered, he had his clerk request that he be given attorney's fees that weren't being requested. I did object to that. And I reiterated in there that I also objected to this going on, that this is the second time this had happened, that he'd awarded something nobody asked for. And so I did object in writing. That's in the record. Next, when you heard these various things stated here about what the court found as findings, I would point out that the court 9 times on critical issues made no findings of fact. That appears in the record on pages 735 through 737. And in the matter of MM, Court of Appeals case, it says, the trial court's required to resolve material disputed factual issues by the findings of fact. Findings by a party attorney asserted some fact or felt some particular way without a finding is not sufficient. Findings must be sufficiently specific to enable the appellate court to review decision. You're in that situation now. You don't know if those things are true or not true that she said up here, because there was no finding by the court that they were true or weren't. They simply said the defendant felt this way, the plaintiff felt this way, went back and forth 9 times. You should read that. There's no findings there. Next, it was mentioned that there was a PPP loan that actually was quite a triumph of the discovery, because in asking questions in a deposition of Sandra Williams, this is one of the things we learned. We learned that they had applied for and gotten a $700,000 PPP loan, which was wrong in 2 ways. One way was the contract required to be voted on by 2/3 vote of the limited partners, which it hadn't been, and they had conceded that. The next way was that it was actually illegal, because if the company that owns the general partner has more than a certain amount of employees, I think the number is 500 or 5,000, they can't get a PPP loan, it's illegal. And so we pointed all this out, and as a result of our action here, they had to give the money back to the federal government, and otherwise FASC would have been guilty of a crime. They would have been charged federally, at least investigated federally. So that was a plus, not a minus. That's something we learned. Additionally, just bear, you asked what things were specifically learned other than that. Well, the first thing we learned was the CFO, Sandra Williams, testifying under oath, testified that there had never been a vote on any of these things. These were things that plainly changed the contract. 14.5 I mentioned earlier, that plainly changed the contract, and she admitted there had never been a vote. And I asked her why. She said, well, there didn't need to be a vote because we're not really in competition. And so these were all things we learned, and we also learned that they had divided this very odd agreement by which they passed limited partner shares to the general partner, and then about 15 minutes later, on the same day, April 1st, 2019, they got the same shares back and also bought the general partner. And the reason that's significant is because they were forbidden to be owner of 100% of the general partner. They were forbidden, but they did it anyway. That's the breach of contract. And so that was a very important thing we learned, and my time's up.
Thank you, counsel. Thank you, everyone.
Thank you very much.
Mr. Clark?